Welcome, everyone. My name is David Giannotti, and I'm with the State Ethics Commission, and I'm going to be presenting information on the state's conflict of interest law. As members of boards and committees, although we're not municipal employees for pay and benefits purposes, we are municipal employees for conflict of interest law purposes, because even though we're participating in our civic engagement, we are volunteering to serve on the boards and committees. Those boards perform important governmental functions. They regulate, they permit, they allow people to do things, and because the boards perform important governmental functions, the members of those boards that make those decisions are municipal employees subject to the conflict of interest law. So I'm going to go through the conflict law generally. There are 29 different sections of the law. I'm not going to touch on all 29 sections. I'm going to hit the high notes on them. But there are a couple of ground rules that I follow when I conduct one of these presentations. I'm not a lawyer, so I don't give out legal advice. But if anyone here came hoping to get legal advice, I will constantly underscore how to do that. And it's very easy. We have attorneys on staff at the Ethics Commission whose job it is to provide you, me, and everyone else who is subject to the law with free, confidential legal advice. So you don't have to worry about everybody knowing your business. We get 6,000 calls a year at the Ethics Commission. In most cases, it's a 5 or 10 minute phone call. And so we encourage everyone, if a conflict presents itself, to not guess. Because if you guess and guess wrong, it can be an oops moment. Also, I encourage questions because I don't know your world like you do. I've been here several times before. Jim has invited me in the past, and I appreciate the fact that he invites us to come out here and talk to the employees. But if you have questions, please, but just keep the questions hypothetical. Keep them prospective. Don't tell me you violated the conflict of interest. I also cannot talk about any actual situations. I don't know if there are any issues of controversy that might involve the conflict law. Can't comment on them. I can only explain how the law applies in a general sense. But if you keep questions hypothetical and you can connect dots, we can hopefully help you out here. So my contact information is on the first page here. So if after the presentation, we appreciate questions because it's going to help the information resonate for all. But if you're uncomfortable with that and you want to go offline, I'll be here after the presentation, or you can reach out to me, tomorrow or what have you. And I'll do my best to provide you the information that you need. So let's talk about it. As members of boards and committees, we are municipal employees. We are town employees for conflict of interest law purposes. The law requires that if you are a town employee, you must always serve the public interest. That means you must always conduct yourself and review matters objectively, consider matters on the merits, act in the public interest. Conflicts of interest are situations where our ability to act in the public interest may be compromised. Those situations come up when we're poised to perform our duties and some component of our private life might be affected by what we do. In other words, our objectivity could legitimately be questioned. So in any situation when you're acting as a board member, when you're performing your public responsibilities, if some component of your private life is going to be affected, if there's this intersection, that's a conflict of interest. Doesn't mean it violates the law, but it does mean that the conflict law applies and can impose restrictions. And so the question becomes how? Well, conflict of interest, when you're talking about performing your duties, it basically falls into one of two buckets: financial interest conflicts and everything else. A financial interest conflict is a situation where you're poised to do your job, but it will affect certain financial interests, yours, your immediate family members, any business that you affiliate with. The law says that as to financial interest conflicts, the first response is you must step away from the matter. The law disqualifies you from performing your duties. And what people have to understand is that when you're a board member, you have responsibilities, you have duties. You may be required as a board member to do X, to participate in X. However, if a conflict presents itself, even though your duties authorize you to do X, the law says no, there's a restriction in place. As to financial interest conflicts, the restriction is you must stay out of the matter. The terms we use at the Ethics Commission to reflect that are abstained and recuse. Now, those two terms mean the same thing in our world. They may have a different meaning in a different context, but it means that the public employee, when faced with a financial interest conflict, backs off because that's what the law requires. Now, there is a workaround on these situations. As I describe the restrictions under the law, I'm also going to talk about workarounds because not all conflicts are significant or egregious. Some involve routine matters, and where there is a conflict, yes, and the restriction applies, but it's not a big deal, there may be a workaround. For financial interest conflicts, there is a workaround if you are an appointed board member. If you are elected to a board position, then the workaround isn't available to you. But that's sort of bucket one, financial interest conflicts. Bucket two deals with every other kind of situation. You're poised to do your job. Some component of your private life is going to be affected. There's no financial interest component. Those situations fall into the section of the law we'll refer to as the Code of Conduct section. Those are situations that create appearances of conflict of interest. Sometimes we hear public employees need to avoid even the appearance of a conflict of interest. Well, what does that mean? Well, generally it's a circumstance. You're poised to do your job. Some component of your private life is going to be affected. Now, the law requires that you serve the public interest nonetheless, but the fact that the circumstance suggests you have some component of your private life creates the appearance problem, because when you're talking about conflicts of interest, it's never an internal analysis. It's never whether you think you could be improperly influenced or you could be bought off because somebody buys you a lunch or what have you. The analysis is always outside in. It's always, what will the public think about this circumstance if they learn of the circumstance? And if the answer is they could become concerned about whether I'm serving the public interest or whether I could be improperly influenced because the matter affects some component of my private life, that's the appearance of a conflict of interest. And what the law requires there, it's not stepping back like a nepotism issue. It says you can continue to do your job despite that kind of a non-financial interest conflict, but you first have to put the cards on the table. You first must file a disclosure, because the public has a right to have confidence in the work that we do as public employees. And they have a right to expect that public employees receive all of the training on all the laws that are relevant to what they can do. And the conflict law can impose significant restrictions. And so where there is a conflict of interest and you are allowed to participate, a disclosure is required, but not an oral disclosure. It has to be in writing. The conflict law supports the public interest by requiring that public employees disclose conflicts where they're going to continue to perform their duties. It creates transparency. Everything we do is going to become part of the public record. And if a public employee has a bias, and that's what we're talking about when we talk conflicts of interest, what are our biases? Who are we favorably predisposed to want to do nice things for? Whenever we're performing our duties and we have a bias, we have to disclose it for the public record. It's a record of the public's business. And so we're going to talk about disclosure as a way to comply with the conflict of interest. And so that's basically conflict law 101. When there is this intersection between your public responsibilities and private interests, red flags should go up. Is there a financial interest component? You need to abstain. If there's not, yes, you can continue to do your job, but you have to disclose that bias that you have. Now that's just high-level review of the law. We'll get into the specific sections in just a little bit. So we have the Ethics Commission, and the job of the Ethics Commission is a 5-member board. And those board members are appointed by the Governor, the Secretary of State, and the Attorney General. Each year, one of those officials, it'll be their turn to make an appointment. The Governor has 3 appointments, the Chairman and 2 other members. The Secretary of State has sort of an off-year appointment, and the Attorney General has an off-year appointment. Those 5 members have full authority under the law to decide what is and what is not a conflict of interest. The mission of the Commission is to administer and enforce the provisions of the conflict of interest law. So the Ethics Commission is a law enforcement agency, not a criminal agency. We don't enforce criminal statutes. We only enforce 2 statutes, the conflict of interest law and another statute that doesn't apply to us here. It's called the financial disclosure law. But the Ethics Commission can impose civil penalties of up to $10,000 for a violation of most sections of the law. The whole point of me coming out here is to say, Let's try to avoid that. Enforcing the law is sort of the least of what we do at the Ethics Commission. Most of what we do is to provide educational services. Our legal division does it when they give advice to public employees one-on-one. My division does it, we go out, I travel 60 to 70 times a year to communities to talk about the conflict law. But our enforcement division as well. We are required by law to operate in secret. We can't talk about what we do at the Ethics Commission. Part of my duties is to handle press calls. My division handles press calls. I have a public information officer. But when we get calls from people saying, hey, did you get this complaint? Hey, are you investigating so-and-so? Hey, did somebody says they called you for advice? Did you give that person? It's all, we can't confirm or deny whether we received a complaint, whether we're investigating any matters, whether anyone has contacted our office for advice, and what, if any, advice we provided to that person. So we have very strict requirements on how the commission reviews matters. The jurisdiction of the conflict of interest law applies to everyone. Anyone who's performing services for government at the state, county, and municipal level. It doesn't matter whether you're elected or appointed. It doesn't matter whether you're full-time or part-time. It doesn't matter whether you're paid or unpaid. For our volunteer members of our various boards and committees, they are public employees, as I've indicated, because of the nature of the service that's being provided to the municipality. And the job of the commission is to administer the law, to provide advice, to promulgate regulations, and enforce the law. Something that we, as I said, we do the least. But in 1 to 2 dozen cases in a year, where the commission determines that somebody has violated the law in a significant way, it will enforce the law and impose penalties. While we have to keep matters confidential, any decision by the commission in connection with an enforcement case where they do impose a penalty and they find that somebody's violated the law, then it becomes public. All matters are confidential unless and until the commission makes a finding in an enforcement case. But our enforcement division, they're involved in the education part of it as well, because we get 1,000 complaints a year. We only resolve publicly about 1 to 2 dozen. So what happens to the rest of them? They stay under the radar. But we never miss an opportunity to provide someone with information about the requirements of the law, what their legal obligations are. So even in cases where we investigate and we think, yeah, there might be an issue under the law, but for whatever reasons, it's not the type of violation that would result in public enforcement action. There's no willful misconduct or self-dealing or some exacerbating conduct that with the conflict violation underpinning it. The commission will resolve, or the staff will resolve those matters confidentially. But we will send out confidential letters to people. Look, we've received this information, we've checked it out, we think there might be an issue here. Here's how the law applies to this situation. If you have any questions, please call our office for guidance. Okay, we don't have a website. The state has a website. We have content on that website. So it was a dramatic shift a couple of years ago. We used to have our own website and we liked our website. But now, as a state agency, everybody moves all their content onto the state's portal. But we have some useful information under the State Ethics Commission banner that you might find helpful. Now, it's not a very deep site because we can't talk about most of what we do, but whatever we can talk about is up on our site. We have educational materials that explain the law. You're all familiar with the online training program and the summary of the conflict law because those are components that you are required by law to complete at regular intervals. But we have educational materials that explain how does the conflict law apply if you're a planning board member. Or if you're a municipal finance manager, all sorts of either by position or by topic. What if I want to work on a campaign, but I'm a town employee? What if I want to engage in some private business practices with the same people I deal with as a public employee, all which raise issues under the conflict of interest law. We have some useful advisories and educational materials. Enforcement decisions, when the commission issues a decision, we splash it. Not because we want to pile on, but because those decisions are instructive to everyone. How does the commission view this kind of conduct? They are posted up on our website, enforcement decisions, because that's public information. And people can find out, where the commission has undertaken enforcement action. And disclosure forms, I'm going to talk about disclosure forms as a way to comply with the conflict law right now. So what you see is an example of a disclosure form. So say you're poised to decide an application and you're acquainted with the applicant. Do you have a potential bias? Well, it depends. Everything under the conflict law depends on the actual circumstances. Say it's a friend or a neighbor or a relative, but it's not an immediate family member or there's no financial interest component. Do you have a bias? Yes. If the answer to the question is yes, a disclosure would be required. So it has to be in writing because of the written disclosure becomes part of the public record of how that business of that application was conducted. Any disclosure to comply with the conflict law must be in writing. The disclosure has to contain all the relevant facts of the bias, and it has to be filed in a specific way. If you are holding an elected office and you have to file a conflict law disclosure, it's filed with the town clerk's office. If you are appointed to your position, such as you're appointed by the town administrator or the board of selectmen, you would file a conflict law disclosure with whoever appoints to your particular position. And they have to keep it as a public record. To comply with public records law requirements, it would be a 6-year period that conflict law disclosures have to be maintained. So on our website, we have a link to disclosure forms. If you have a conflict and you want to find out whether you need to file a disclosure and you look on our disclosure forms, you're going to see that we have over 30 different forms. Don't guess and don't try to figure out what the right form is. Your eyes will glaze over before you figure that out. If you find that a disclosure may be required, please call our office and talk to the attorney in our legal division who's taking calls that day. We refer to that person as the attorney of the day, the AOD. You call that person, they'll get you to the right form. The good news is we have the forms all pre-filled. You don't have to create a disclosure out of whole cloth. We have the forms all pre-filled. All you have to do is once you find the right form, you're filling in the fact pattern that constitutes your bias. And then our AOD can help you fill it out correctly, file it correctly so that you're complying with the conflict of interest law. And these disclosures are public records, so they have to be maintained. If a member of the public or the media, if they learn about a potential bias that you have on something that your board is considering and they want to know, did you disclose that potential bias, those records would be produced. Okay, so let's talk about the conflict of interest law. We're going to break it down into categories. The first category being the gift restriction rules. The question being, can you accept a gift from someone? Well, under the conflict of interest law, the answer is always, it depends on the circumstances. And really the threshold issue is your public position implicated in any way, shape, or form in connection with a gift that someone gave you? In other words, gifts not related to your public position do not implicate the conflict law. Gifts that do implicate your public position implicate the conflict of interest law. Now, I have a reference to bribery. We have a section in the conflict of interest law that prohibits bribery. Now, bribe and corrupt acts. It's the one section of the conflict of interest law that deals with corruption. A bribe is a corrupt act because it is an effort by someone who may need something from the public employee, something the public employee can provide, to corrupt the public employee. The corrupt element of a bribe is something called a quid pro quo. Do you know what that is? Basically, it's an exchange. I give you this, you give me that. Under the state's conflict of interest law, it's a violation for anyone who's dealing with a public employee to corruptly offer or give, or for a public employee to corruptly solicit or receive. And when I use the word corruptly, that means quid pro quo. To offer anything of value if the intent of that offer or giving the item of value is to get the public employee to do something, to not do something, or there's some collusion to commit a fraud on government. For example, if I'm driving here and I'm late and I'm on the pike and it's wide open, which it never is, but for some strange reason there's room to travel and I goose the car a little bit because I'm running late, and all of a sudden I'm doing 80, 85 on the pike and I get stopped by the state police. What's the chances I'm going to get a ticket for doing 85 and a 65? About 100%. So I produce my license and registration and I tuck a $100 bill in that mix and I don't say anything. There are two parties to that exchange and everybody knows what that $100 bill means. In other words, in 10 out of 10 times, you would write a ticket for someone going that fast over the speed limit, but for this $100 bill, there's an explicit understanding that for the item of value, rather than handle the matter the way you normally would, you're going to do something else. You're going to not do something that you would otherwise do. It's an effort to corrupt a public employee. The point under this bribery section is that both parties can violate the conflict law. And the deal does not have to be consummated. The mere offer triggers a violation. The mere solicitation triggers a violation. And recognizing that the bribes involve overt corruption, while the commission can impose civil penalties of up to $10,000 for a violation of most sections of the law, for this section it's $25,000. So it's very significant. And also, there are criminal penalties that can attach to a violation of the bribery section. It would not be the Ethics Commission involved in any criminal investigation. It would be the AG's office or a district attorney's office. But the criminal penalties for violating the bribery section of the conflict law can be a jail term of up to 10 years and a fine of up to $100,000. If it's the commission knocking on the door, it's a potential civil penalty of up to $25,000. It's a section we deal with the least at the Ethics Commission. And although I'm not a lawyer, I don't get confused about any questions that come in about whether somebody can bribe a public employee. The answer is always no. There's no gray area there. But once in a while, we'll get some issue where, some public employees on the front page of the paper sticking money where it doesn't belong, and the conflict of interest law is able to deal with those kinds of situations if it is the commission as opposed to the AG, investigating the matter. The middle bullet point deals with gifts to public employees that are worth $50 and there's some business going on between the public employee and the gift giver. The conflict law establishes a threshold, $50 or more. The term in the statute is substantial value. And the law says it's a violation for anyone to offer or give to a public employee, or for a public employee to solicit or receive anything that is of substantial value and given for or because of some official act performed or to be performed. And that's just to translate it into, there's some business going on. The gift giver has some business involving the public employee. So if a gift is given and it's worth $50 or more, it is prohibited. Again, both parties can violate the conflict of interest law. Like if someone improperly gives Red Sox tickets to a public employee, we can hold the public employee accountable for violating the gift rules and also the giver for violating the gift rules. Both would be subject to a $10,000 civil penalty because there's no obvious effort to corrupt the public employee. In other words, a gift given for or because of some official act sounds like the nexus, sounds like there could be a quid pro quo, but there's not a quid pro quo. It's just the gift is given and there's some business going on between the giver and the public employee. But there's no quid pro quo involved. But both parties can violate, and the potential civil penalty is up to $10,000. The bottom bullet point represents the threshold gift restriction rule that we all have to understand if we understand nothing else. It was put into the law in 2009 when the conflict law was amended and other state statutes were amended, but it basically takes out the nexus. It keeps in the public position but takes out the nexus. It says that public employees, you cannot solicit or receive any item of value that's worth $50 or more and given because of who you are as a public employee, because of official position. So to summarize, in connection with gifts from people, if your public position is implicated in any way, shape, or form, even if it's a mixed motive, it could be a gift from a friend, but if it's given where that friend has some application pending before your board, they may say, well, I'm giving you the gift because you're my friend, but if they're also thinking, well, and this might also help make sure I get you to do this. Gift giving is restricted under the conflict law because we're required to serve the public interest, and gift giving can undermine that process where the public has a right to have confidence in the work that we do. Because when we're in government, when we're serving on these boards, what are we doing? We're telling people yes and we're telling people no. The people we say yes to, they love us. The people we say no to, maybe not so much. But some people might be attempting to leverage relationships with public employees to get what they want. Improperly leveraging relationships to get the public employee to maybe shift up to what they would normally do or decide in connection with the matter. So the law has this $50 threshold. $50 or more connected to some official business or tied into your official position, problematic. Any gift that involves a quid pro quo, doesn't matter what the value is, problematic if it's tied into your official position. So, what about gifts that are worth less than $50? We're not prohibited as public employees from accepting gifts worth less than $50, but those situations can create appearance problems. If you accept somebody buying you lunch or dinner and it's less than $50, but then as a public employee you're going to continue to have dealings with the gift giver, that creates an appearance problem. The example I use to illustrate this point is that of a school teacher. So say I'm a school teacher in the community and the parents of one of my students have given me a $40 gift certificate to my favorite restaurant. I can accept it because it's not worth $50 or more. If it were, I'd have to refuse it, but $40, I can accept it. Does it create an appearance problem? Depends on the circumstances. Not all circumstances create appearance problems. For example, if I were to get the gift certificate from the parents at the end of the school year, as a teacher, I have my official dealings with people, but I'm not going to have any more dealings with the parents because it's at the end of the school year, and I get the gift certificate. It doesn't create an appearance problem. The appearance problem is created not when I receive the gift, but when I'm next poised to have official dealings with the giver. At that point, before I have dealings, the appearance problem is in place, a written disclosure would be required. So for example, if I got the gift certificate from the parents in the middle of the school year, and oh, by the way, they also asked me to write a letter of recommendation. They're trying to get their child in, say, a competitive AP class. And many of the other parents have made similar requests, but they didn't give me a gift certificate. What are those parents who didn't give me a gift certificate going to think about the fact that these parents gave me the gift certificate? They're going to be concerned. You know, is their request for a letter going to the top of the pile, say at my expense because I made a request but I didn't give them a gift certificate? Is their child going to get more of that teacher's time at the expense of my child to learn the material to give them some sort of competitive advantage? So the way it works with gifts under $50, we can accept them as long as there's no quid pro quo, and who's going to bribe someone for $40? As long as there's no quid pro quo, we can accept it, but if it creates an appearance problem, in other words, if we're going to continue to have dealings with the giver after we receive the gift, a disclosure would be required. Also, the commission can aggregate where there are multiple occurrences from a single source. So say, as a public employee, you're dealing with a vendor, they buy you lunch and it's $15, but it occurs monthly for a 5-month period. The commission says that multiple occurrences from a single source within a 365-day window, those individual amounts will be aggregated. Once you get to $50 or more, it then becomes actionable. Okay, here are the types of items of value that we deal with at the Ethics Commission. The payment of meals, people who provide event tickets, either to sporting events, theater, what have you, to public employees, travel or expense reimbursements, gift certificates, floral arrangements, fruit baskets, and so forth. These are the issues we most commonly deal with. Besides event tickets, I have a reference to an advisory. In 2004, the Ethics Commission issued an advisory to public employees on accepting event tickets. Now, who can remember what happened back in 2004 that might have necessitated an advisory? Basically, the way it works is that public employees call us and we deal with them one-on-one and we give advice. Sometimes we get inundated with similar calls, and that happened back in 03 and 04 because of the Red Sox and the Patriots. And so public employees, you know, public employees don't necessarily have season tickets in the luxury boxes, but some of us hang out with the people who do. You know, those that deal with vendors, they deal with consulting firms. Those private companies, those big firms, often they have season tickets to the sports teams and the luxury boxes, and they use those tickets to entertain clients. Public agency employees are clients just like everyone else. And so when it came to the Red Sox and the Patriots, public employees were calling and saying, I've been invited by this vendor to the World Series, to the NFL playoff game or what have you. So the commission decided to issue an advisory. We have numerous advisories on our website depending on the topic. Event tickets being one, political activity being one, job recommendations, so on and so forth. With the event tickets, the commission made a couple of points because public employees were saying, look, what if I pay for the tickets? And so the commission advised, well, number one, before we talk about you paying for the tickets, let's talk about the access. You know, if you're being able to see a game and you're sitting in the luxury box, you're being given access to an event that an average member of the public doesn't share. And that special access in certain circumstances, in and of itself, is an item of substantial value. So that makes it problematic under the gift rules. But if you pay for the tickets and you pay face value, what's the actual value to a World Series game or the Super Bowl? Is it face value? Not by a long shot. The commission said we're going to use actual value, not face value, to determine the value for the gift restriction purposes. And if you pay face value for a ticket and the actual value exceeds face by $50 or more, that also is problematic under the law. And then also public employees are saying, well, what if I pay the full value for the ticket? And the commission said, if you're not to the plus by $50 or more, there's no implication under the gift restriction rules. But understand that you're just picking your poison, because you may not be violating the conflict law, but you're certainly violating scalping laws, because they're not licensed to sell you that ticket for anything other than face value. Anybody who sells a ticket for $1 more than face or $1 less than face, they're violating the scalping rules under Massachusetts law. So in the advisory, we were saying the best judgment is don't take tickets. Those situations can blow up on you. So that's an example of an advisory. Let me give a quick quiz. So somebody that you see in town hall, you're attending your meetings, and you have certain people that are always appearing and certain people the public shows up. But in any event, you're in town hall and somebody walks up to you, in connection with the board meeting before it starts, and they hand you a $50 scratch ticket. And the only reason they're giving you that scratch ticket is because of who you are as a board member. Can you accept it? No, there's an implication of your public position. What happens if you succumb to the temptation, you scratch the ticket, and it comes out of your face? It still costs them $50 or more, so it's problematic. But what, however, if they give you a $2 scratch ticket? Can you accept it? Yeah, it didn't cost them $50 or more. What happens if you scratch it and you win $10,000? It's your lucky day. It only costs them $2. Does that create an appearance problem, however? Most certainly. So if there's an implication of your public position, while you can accept a $2 scratch ticket, any winnings would have to be disclosed. Now, workarounds. So those are the restrictions. Bribes prohibited. Gifts worth $50 or more given in connection with some business, prohibited. Gifts worth $50 or more given because of your official position, prohibited. But we have regulations in place that say, look, in certain circumstances, while the conflict law gift restriction rules are implicated, it's not going to be a violation if certain conditions apply. Travel. The ability of employees to travel and have third-party entities pay their expenses if the travel serves a legitimate public purpose. In other words, it's educational or informational in nature. For example, sometimes when the governor goes on trade missions, we learn that the expenses for the governor and the governor's staff to go on a trade mission are paid by private companies. Now, the conflict law gift restriction rules apply to the governor just like the rest of us. How can the governor have those expenses paid for by private companies? Because there's a regulation that the Ethics Commission has promulgated that says public employees can travel and have their expenses paid for privately if the travel itself serves a legitimate public purpose and the public employee discloses the nature of the travel and the expense reimbursements. In other words, creates transparency. There's also a mechanism that says the public employee who's going to have the expenses reimbursed has to file a disclosure to create transparency, but you file it with the agency head, whoever the appointing authority for that public employee is, has to make a determination that the employee's attendance at the event serves a legitimate public purpose. So that's sort of a workaround where, back in 07, 08, when the economy downturned in a significant way, public agency budgets had to get retooled, and the most common budget that got cut was travel, and public employees, just like everyone else, attend conferences. If you're the town engineer or you work for the town planning department, there are conferences that people just like you attend, and these conferences are where public employees learn how to do their jobs better, just like everyone else. It's where we network, it's where we learn best practices, it's where we learn incidental hospitality, if public employees are invited to events and some private entity hosting the event is serving food and beverage, if we file a disclosure, we can accept the food and beverages. Even if it's de minimis like coffee and pastry, people still get the wrong idea about that stuff. So a disclosure process and permission from the agency allows us to accept any hospitality. Sometimes it could be a catered meal. You know, if I work with a vendor and the town bought some fancy software from the vendor and now we got to figure out how to use it after we completed the procurement process. So I'll be traveling to their facility for a week to learn how to use this software, and they're going to feed us every day. You know, a catered meal is going to be something that's more than $50, a direct implication of the gift restriction rule. So this regulation dealing with incidental hospitality covers those items that are de minimis and those items which directly implicate the gift restriction rule. And then random drawings are allowed because the gift restriction rules really seek to restrict efforts by people to leverage their relationships with public employees by providing them with items of value to them personally. When you're talking about, you know, a conference where there's going to be door prizes, those aren't being targeted to public employees personally. Those are available to anyone who attends the conference. So where there is no purposeful individual targeting, public employees can accept random drawing winnings just like anyone else. So if you go to a conference and everybody who does what you do in all of the towns in the state are at a conference and the host is some private entity and they're having iPads as door prizes, you know, you can put your business card in the fishbowl, and if you get picked, you can accept it without violating the gift restriction rules. Unsolicited perishable items, it's a big one for public employees who deal with vendors, because people like to do nice things. They're not always trying to corrupt or improperly influence public employees, and nobody's ever going to be corrupted by a floral bouquet or an edible fruit basket. But those items cost $50 or more. There's a direct implication under the conflict law. But by regulation, the commission has said, hey, as to unsolicited perishable items, and unsolicited being operative, public employees can accept these food items without violating the conflict law if, and what I say is if you can remove the element of the crime, so to speak, that being the $50 rule. And how do you do that in connection with food items? You share the items. But the mechanism under the law is you don't accept those items on your own behalf, you accept it on behalf of the agency. You accept it on behalf of the town. And the mechanism to demonstrate that is you accept it and it's shared with everyone, so it's accepted by the agency. So we can accept unsolicited perishable items without violating the conflict of interest. So that's just to give you some flavor that there are workarounds by regulations where even though the gift restriction rules are implicated, where there is no conflict or mischief, or it can be controlled, the workaround is available. Now let's talk about financial interest conflicts, what we call nepotism issue. It falls under the section of the law we call nepotism self-dealing. You're a board member. The conflict law says, as a board member, you may not participate in board matters if certain financial interests are going to be affected. First, yours. Next, your immediate family members. Not all of your relatives, just your closest in ones, and we'll review who they are in a second. Third, business organizations. If you own or operate a business, or you're privately employed, then as a board member, you have to stay out of matters that might affect those financial interests. If you have a business partner. Also, if you're negotiating for employment. You're on the town side making decisions regarding someone, but privately, you're also negotiating for employment with that entity. The nepotism section says as a town employee, you cannot perform your duties if what you will do will affect the financial interests of anyone or any entity with whom you are negotiating for employment. Why? Because the public, where they expect you to serve the public interest, is going to wonder, and they're going to be concerned if they know that on the town side, you're making important decisions regarding an applicant, for example. On the private side, you're negotiating for employment. Are your town decisions going to be impacted by that? Are you going to decide matters differently than you otherwise would because you happen to be negotiating for employment with the entity? Now, there is a workaround. The workaround is for financial interest conflicts, which yes, feature a financial interest component, but are not that substantial. And the workaround is where you have a financial interest conflict, you must first step back. But one of the things you can do is file, if you are an appointed board member, you can file a disclosure with your appointing authority, the Board of Selectmen, for example, of your financial interest. The Board of Selectmen would then decide what to do about your conflict. And there are one of three things, and it doesn't really apply cleanly to boards than it does to appointed employees, but the three things that the appointing authority can do with the financial interest conflict disclosures, they can take responsibility for the issue from the employee and handle it themselves, which isn't really practical for board members. The second thing is the appointing authority can assign some other entity to handle the matter. But the third thing that the board can do is waive the statute. If the appointing authority is willing to make a determination that the integrity of your services are not going to be affected by your handling the matter, even though you have a financial interest conflict in it, it waives the statute. Now, for boards, it's not very clean. But if this was a situation where, say, I were a department head, and say I'm the police chief, and I have a son or a daughter who's a patrol person in the department. Now, I didn't hire them. That's a serious violation under the conflict law, and I don't supervise them. But one of the things I have to do as a department head, once every 2 weeks to comply with municipal finance law, is certify the payroll for my department. That consists of me putting my name on it. I don't prepare the payroll. It's just a ministerial act of signing off on something. But if I have say a son or a daughter or an immediate family member in the department, that's a nepotism issue. Because by signing off and certifying the payroll, everybody gets paid. So I'm participating in a matter that affects the financial interests of my immediate family member. If I don't sign off on the payroll, nobody gets paid. And how do you work through that? Well, the mechanism under the conflict law is the employee can file a disclosure with their appointing authority, and the appointing authority can resolve the conflict by doing one of those three things: handling the matter themselves, assigning someone else to handle it, or waiving the statute by making the determination that the integrity of the services that they can expect from the employee won't be affected by them handling the matter. If you are an elected office holder, you don't have an appointing authority. Elected office holders, when they encounter financial interest conflicts, they must step back. But we're going to talk about workarounds within that framework as well. And understand that financial interests, especially for you folks that serve on boards where you're dealing with property issues, if you are in a butter or if the applicant is a business competitor, and the argument can be made that either your property rights or your business interests are going to be affected by what the board does regarding an abutter or business competitor, the conflict law will apply. Like, for example, so say I own a package store in the town. Can I serve on the liquor license board? Most people say no, but the answer is yes. I can. The law doesn't preclude any class of citizenry from serving in government. It only imposes restrictions once you begin serving in government. So I can serve on the liquor license board even though I own a package store, because the license board does more than just deal with package stores. They deal with one-day licenses, they deal with full liquor licenses, they deal with a host of other types of business entities that sell alcohol. So say there are 3 package stores in the town and I'm on the board, and one of my competitors gets caught for serving somebody who's underage, and now they're coming before the board and they're facing a possible loss of license for a period of time. Is that a matter that's going to affect my financial interest? I'm a board member who owns a package store. It's called a rebuttable presumption. If the answer to the question is yes, we're business competitors, so naturally if this store is shut down, they're going to come to my store, then my business interests are affected, then it's a nepotism issue. But if I'm in Worcester and there are 100 package stores and my business is on the east side of town and the offending competitor is on the west side of town and we don't share a customer base, then no, my financial interest wouldn't be affected. But so it applies to business competitors in certain circumstances, and it applies if you are in a butter. If an argument can be made that your financial interests are affected, the nepotism section will apply. So immediate family members. The term appears in the statute. You can't participate in matters affecting your financial interests or the financial interests of your immediate family members. And that term is defined in the statute as reflected on the chart. It refers to you, your spouse, your parents, your spouse's parents, your siblings, your spouse's siblings, and your children, your closest in relatives. You have to stay out of matters affecting your financial interests or their financial interests. But this then begs the question, what about my other relatives? What about those folks who are related to me but they're not reflected on the chart? We'll refer to them as non-immediate family members. What does the conflict law say about my ability to continue to perform my duties if a matter affects the financial interests of a non-immediate family member? Well, for it to be a nepotism issue, in that nepotism bucket, the person has to fit the definition of immediate family. If they don't, then it's not a nepotism issue. Now, who are these non-immediate family members? Cousins, aunts and uncles, nieces and nephews, grandparents, grandchildren, ex-spouses, domestic partners. They're not on the chart. They're not an immediate family member. If a matter comes before your board affecting the financial interests of somebody who's not on the chart, it's not a nepotism issue. You're not required to abstain. But by default, it kind of rolls from the nepotism bucket into the code of conduct bucket. With that kind of a situation, you're poised to do your job and it affects the financial interests of a cousin, for example. Do you have a bias? Would the public become concerned about whether you're serving the public interest or favoring the bias? The answer is yes. So you can participate in matters that affect the financial interests of non-immediate family members or friends, same grouping, provided you first file a disclosure of that bias. If you're elected, the disclosure goes with the town clerk. If you're appointed, the disclosure is filed with your appointing clerk. Now, also, the conflict law serves the public interest by allowing the appointing authority to manage the process. In other words, you may be required to file a written disclosure to create transparency, but it gets filed with the agency via the appointing authority so that the agency can make the best decisions for the agency. And that might be, okay, you're complying with the law by filing the disclosure, but I don't want you handling it. This can blow up on us. And agencies are allowed to do that. So when public employees call us about these appearances of conflict of interest, especially under the gift restriction rules, we tell them, while the conflict law says yes, make sure you check with your agency because they may have a different rule. Like Massport. Massport is a state agency. They have a policy, a zero tolerance policy on their employees accepting any item of value from anyone that has any dealings with Massport. So it doesn't matter what the conflict law says. Massport policy controls. So in situations where a public employee might file a disclosure, look, I've got to sign off on this contract that's going to a company that employs my cousin, and they're going to get compensated for the work under the contract. I filed the disclosure with my appointing authority. I'm complying with the conflict law, but it may be within their prerogative to come in and say, no, you're not going to go and sign off on that contract. We're going to reassign that to someone else because we don't want situations blowing up and becoming front page stories. Even though you're complying with the conflict law, it doesn't mean the situation won't blow up. I can't manage that as the agency head or the appointing authority. I can't manage situations that I'm not aware of. So the law says you have to disclose in writing that bias so that I'm now aware of your potential conflict and we can make decisions in the best interest of the town, the department, the agency, what have you. Okay, town board members, the rule of necessity. On a nepotism issue, you have to step back. You're not allowed to participate in the matter. But what happens if the board can't put a quorum together because too many members have financial interest conflicts so that the board can't perform its statutory responsibility? That's not workable. So there's a provision that's been crafted by the courts, it's not in the conflict law, called the rule of necessity. It only applies to elected boards because they don't have appointing authorities. For appointed board members, if you encounter a financial interest conflict, you can file a disclosure with your appointing authority. If the board can't put a quorum together because too many members have financial interest conflicts, They can all file disclosures with their appointing authority, and the appointing authority decides what to happen. But if it's an elected board, they don't have that option. But there is something called the rule of necessity. The rule of necessity allows a board to continue to perform its statutory responsibilities even though members have financial interest conflicts that would otherwise apply. It has to be a last resort. The Ethics Commission has an advisory 0505 on the rule of necessity. We explain how to legally invoke the rule, because if a board improperly invokes the rule, then the members who relied on the safe harbor created by the rule don't get that safe harbor. And what we say is it's got to be a last resort. If it's something that, well, the board member's absent and we can wait a week, and when they come back they don't have a conflict, then we can achieve a quorum, you have to wait a week. But if there are circumstances where, look, if we don't act on it this week, by default it's an approval and we can't wait, well then it might be a legitimate invocation of the rule of necessity. So the example I use is, say I serve on the planning board and the planning board is elected. There are 5 members of the planning board, and the planning board decides on major developments in the community. And Walmart has submitted an application. They want to put a big box store in right next door to my house. Is that a nepotism issue for me? Yeah. What happens if 2 of my fellow colleagues on the board also live in the same neighborhood as me? They're abutters, and their financial interests are also going to be affected. All of a sudden, 3 out of your 5 board members can't participate because they have nepotism conflicts. The board can't perform its statutory responsibility. That's not workable. So the courts, in a decision on this kind of an issue, crafted something called the rule of necessity. And we allow boards to use the rule of necessity in that issue where the board can't act. And it's a last resort. There is no other mechanism for this business to get conducted. There's no other board that this responsibility can be passed on to. The board can invoke the rule. One of the affected members at a meeting, the relevant meeting where the matter is going to be considered, simply invokes the rule. And all of the members who have the conflicts have to then disclose what their specific conflict is. It's got to be disclosed for the minutes. The first thing we tell boards is, before you consider invoking the rule, obtain legal advice about whether you're invoking the rule is appropriate or not. Because again, if you improperly invoke the rule, you don't get the cover the rule affords. But once you get advice, either from the Commission's legal division or from town council, that it's proper to invoke the rule, then one of the affected members invokes the rule, then all of the members that have these nepotism conflicts must disclose for the record, for the minutes, the nature of their conflict, and then everybody gets to participate. There's a public disclosure. Transparency is created concerning that event, so the public can look at that and know, okay, they were conflicted, but they invoked the rule, they fully recognized this issue. Now, it's possible to improperly invoke the rule. We had a situation involving a city council in one of our cities around Boston where there was this very significant development issue. There were 7 members of the city council. 4 of them had conflicts. 2 of them had nepotism conflicts. The other 2 only had code of conduct conflicts that could have been cured by the filing of a disclosure. But the chairman, he was one of the nepotism conflict guys, and he didn't like that arrangement of him not being able to participate. So when the matter came up before the city council, he invoked the rule of necessity. And all 4 members said they had to abstain because they had financial interest conflicts, and then they invoked the rule and everyone participated till we found out. And then we told them, you 2 had to abstain from the matter. You had financial interest conflicts. You 2 did not. You could have participated. The board could have achieved a quorum. And so you 2 board members, you don't get the protections that the rule affords because the board improperly invoked the rule. And that's why we say, before a board contemplates the use of the rule, get legal advice to make sure it's proper. Okay, now, abstaining. This sometimes confuses people. I have a conflict of interest. Do I have to abstain? Not necessarily. If it's a financial interest conflict, yes. But if you're appointed, you can file a disclosure with your appointing authority and they can give you permission to participate if they think it's appropriate. But if you do need to abstain, what's the proper way to do it? We see situations where somebody will say, I'm abstaining, and they remain at the table. Other situations where they say, I'm abstaining, and they go sit in the audience. And then other situations where somebody says they're abstaining and they leave the room. Which one is correct? A, B, C, or all of the above? All of the above. The law only says you cannot participate. It doesn't then set out procedures for what you have to do next. Now, you can't participate. You cannot engage in any activity in furtherance of that issue. You can't vote. You cannot discuss. And people sometimes think, well, as long as I don't vote, I can talk all I want. No, you cannot. You cannot participate in any way, shape, or form. You cannot vote, you cannot discuss, you cannot glare at anyone, you can't share hand signals, you can't lobby members outside of board meetings, you can't coerce anyone to do anything. Any substantive participation in a matter where you are required to abstain violates the conflict law. Now, somebody that abstains and remains at the table, fine, as long as they don't participate. But is that the wisest course of action? Arguably not. Because where people can make complaints that town employees violated the law in an effort to leverage something that they want, sometimes they make complaints, and we get it. And then we got to sort them out. And when it's a nepotism issue, we want to make sure that we're comfortable that there was no violation of the law. So while you can remain at the table, as long as you don't participate, you're complying with the law. But you may not be doing everything to insulate yourself from somebody calling the Ethics Commission and saying, you did participate. And it goes along the lines of, they participated, violated the nepotism section. Well, what did they do? What do you mean? Well, did they vote on the matter? Well, no. Did they discuss the matter? No. Well, what did they do? Well, by their very presence, they intimidated their fellow board members so they dared not vote against that person's interests. Well, that never happens. We all know that. But that doesn't mean when we don't get a complaint that we don't review it. And sometimes we decide we need to talk to people. And if we're doing our jobs, we're going to do it discreetly. And we'll get to the end game that says, yeah, the board member didn't participate, there's no issue here, it was a bogus complaint. But in investigating and dealing with those matters, after we're done and we get to that end game, and we're telling the person, yeah, we're not going to investigate further, I've never heard anyone say, thanks, that was nice, let's do that one again real soon. Arguably, it is an intrusive process, but arguably absolutely necessary in furtherance of the public interest. You not only want to comply with the conflict law, you want to always understand the optics. You're not doing this for the fame, glory, and compensation. This is part of your civic engagement. You certainly don't need us interfering in your life because somebody reported that you violated the conflict law. So look at the optics, and in those situations where they can potentially blow up, you want to think, look, if I don't have any skin in the game, why am I going to stay at the table? You can, but you take your chances. But then we see situations where somebody abstains and goes sits in the audience. Look at my Walmart example. Say I'm the only person who's affected with a financial interest conflict. So as a planning board member, I can't participate. But you know what? I don't lose any of my rights because I serve on the planning board. I'm a resident, a property owner, a voter, taxpayer. And while I can't participate as a planning board member, I'm certainly going to be heard as a resident, and I'm allowed to do that. So where I abstain as a planning board member, I can go sit in the audience. And when the public hearing happens, as long as I'm not wearing my planning board hat, I can participate in the public hearing process without violating the conflict law. Now, it's never a good idea to say, yes, I'm a resident of such and such a street and I'm opposed to this application, and oh, by the way, we just talked at executive session and all the board members. No, you've just put on your planning board hat, you've just violated the law. You can represent your own interests, but you have to be careful as to what hat you're wearing. You cannot use your public position where you're required to abstain. And then we have the situations where people abstain and leave the room. Now, why would people do that if the law doesn't require it? Well, because when I'm talking about insulating yourself in optics, you want to think about the effect of that. The court said in considering this kind of an issue, in its decision, they said, the wisest course of action is to leave the room. Why would they say that if the law doesn't require it? When you leave the room, you remove all doubt. Nobody can then allege that you were exchanging hand signals with anyone. You weren't even there. So you want to consider, if you have to abstain, this is what it can entail. You just don't participate. But think about what's the best for yourself, your reputation, the integrity of the town and your board. Okay, now we move from the nepotism section to the code of conduct section. And I've already talked about appearances of conflict of interest that require disclosure. The language of the statute is that you as a public employee, as a board member, you may not act in a manner in which a reasonable person, knowing all of the circumstances, could conclude that you would act with bias. Providing further that if you disclose the nature of the bias in a manner that is public in nature, it dispels the appearance problem that's otherwise created. So the mechanics are, if you participate in a matter and some component of your private life is going to be affected and you don't disclose it, it's reasonable to conclude that you were improperly influenced, that you favored that bias. But as a matter of law, when you disclose the bias in advance, it dispels the appearance problem. When you take the time to put the cards on the table before you do anything where you have a bias, it dispels the appearance problem such that it's no longer reasonable to conclude that you were improperly influenced or could be improperly influenced. As a matter of law, it takes care of that. Yes, Jim?
Yeah, could you, so far we've talked about conflicts that benefit the individual or member of the family. But there was a recent ruling by the Ethics Commission about a case out of Dedham, I believe. Went back and revisited something. The selectman was found to have shown bias against somebody.
Adverse treatment.
Yes.
We're going to talk about that right now. We haven't gotten to it yet. Yes. See, you know this stuff, so you're telegraphing here. Along with appearances of conflict of interest, the law under the Code of Conduct section also restricts what we call improper use of public position. Public employees may not use their public positions to secure benefits for themselves or others that they're not otherwise entitled to. This also applies to your ability to use your position to retaliate, to take adverse action. Both apply. And I don't know if it was a Dedham case, but we did have a case where we took action against a building inspector, where this, and it was during the building boom during the 90s in one of the communities, where this one contractor, a framing contractor, they had constant building permits outstanding and they needed inspections from the inspector. And the contractor hired the inspector's son as an employee doing framing work, and the son wasn't very good at doing the framing work. So the contractor ended up terminating the son. Well, the building inspector didn't like that one bit. So where the building inspector had always been Johnny on the spot performing inspections, approving those inspections, once the contractor fired the son, all of a sudden the building inspector wasn't showing up, was being very nitpicky on the building code, failing inspections that were previously approved. In other words, using his position to retaliate against the contractor. And we took action against the inspector in those kinds of cases. So he's correct. Whether it's adverse action or favorable treatment, the conflict law prohibits both because it constitutes an improper use of your public position. The law says that I cannot use my public position to secure for myself or others unwarranted privileges that are of substantial value, that term meaning worth $50 or more, and not available to similarly situated individuals. And what that means is recognizing that in government, we're required to treat everyone the same. We're required to serve the public interest. And in any instance where a public employee deviates from the normal rules that guide what they do and somebody benefits as a result, it's unwarranted. So, for example, say I work in town hall and I issue one permit. Because you have so much oceanfront property here in Southborough, say I issue the beach stickers. And anybody that wants a beach sticker has to come to me in town hall. They have to fill out a permit application, and the fee for a beach sticker is $100. We have to get it up over $50. And everybody that wants a beach sticker has to follow that process. And then one day my Uncle Harry comes in and he wants a beach sticker, and I tell him, Uncle Harry, today's your lucky day. Today you get the friends and family discount. You got to fill out this application, but you don't have to pay the fee and I'll give you the sticker. Well, in that instance, I've improperly used my public position. I've secured a benefit from my Uncle Harry that he's not otherwise entitled to. It's an unwarranted privilege because in doing my job, everyone has to fill out the application, pay the fee. I'm not authorized to give out a friends and family discount. So in any instance where a public employee deviates from the normal rules that guide what they do, and as a result of that deviation, someone they're connected to privately benefits or is adversely treated, it violates the conflict law. Like somebody comes before my board and that SOB sued me 15 years ago and I'm still bitter about it. Is that a bias for me? Yeah. You know, so if I say, well, you know what, we always approve these, you know, on the planning board, it's a Form A application and we approve them as a matter of right, but I don't care. I'm not approving this Form A application. This guy's gonna rot in hell before I get that. That would be using my position to retaliate and I would be violating the conflict of interest. So this provision, this improper use of public position, this prohibition about using a position to secure a benefit, extends to the use of public resources. Public resources are to be used for the conduct of the public's business. Any non-public use, any private use of a public resource that can be quantified at $50 or more violates the conflict law. So I work for the DPW and we've got a snowstorm and I'm out plowing and I have my roads that I plow, serving the public interest. And one of the things I like to do because I'm charitable in nature is whenever I'm out plowing, I go to my church and I plow out my church parking lot. Is that a problem? Doesn't seem like a problem. Seems like a very charitable thing to do. Oh yeah, it's a problem. Why? Because I might be a resident of the town and my tax dollars pay for those services. And I don't go to that church. I go to the church over here. So when you're done plowing out your church parking lot, shag it over to my church and you plow out that parking lot as well. And don't I have the right to expect that? We had a case involving a DPW director and deputy director. Now the town just spent all sorts of money on a handy dandy chipper because they're trimming trees around the roadways. And the deputy director had a brilliant idea one day. You know, we use this chipper, but you know, we don't work on the weekends. And I need to take some trees down on my property. So he goes to the director, who's not properly dialed in, and he asks him, hey, do you mind if I take the chipper home this weekend? I've got a couple of trees I need to take down on my property. The director said, we're not using it. Yeah, why not? Why is that a problem? Because if I learn about that and I need trees taken down on my property again, I'm a resident, I'm a taxpayer. And I'll go to the director and say, that was a very nice thing you allowed the deputy director to do. The next available weekend, I need to take a chipper on my property too. Now that's unworkable. Now when you're talking about town equipment, once it comes off the lot and gets put into service, what happens? It depreciates. So the argument, well, nobody's using it. Well, no, it's depreciating from the moment you start using it. It has a shelf life. It requires maintenance. It requires town resources for upkeep and so forth. And so that stuff has to be used for town business only. And so it would violate the conflict of interest law, using public resources for a non-public purpose. Also political activity. The general rule under both conflict of interest law and campaign finance law, although you'll hear this from Jason from OCPF next week if you come. Both say the same thing. Both laws say the same thing for different reasons. Public employees cannot engage in campaign or political activity on public time, in public buildings, using public equipment and supplies. To do so constitutes an improper use of public position to secure an unwarranted benefit for whoever the candidate is. And we'll talk about that in a little bit. But before we do, I want to talk about disclosing confidential information. We work for government. We're public employees. We understand that public records law says that a document created by a public agency is a public record unless it's exempt from disclosure under the public records law, unless there's some other statutory provision that says it's confidential, like everything the Ethics Commission does with limited circumstances. It's confidential by law enforcement. But as members of town boards, you may encounter confidential information as well. Stuff that happens in executive session. If you're considering bid information. In the public sector, personnel information, medical information, all stuff that is public. Query information, if you're poised to hire a position and somebody needs to go through a query check. Confidential. Public employees who receive or review confidential information are required to keep that information confidential. Any improper dissemination of confidential information to somebody not authorized to receive it may violate the conflict of interest law. Now, inadvertent disclosures, they don't get our attention. What gets our antenna up? Any improper disclosure of confidential information to further a personal purpose. A member of some board is talked off because they meet in an executive session. They're talking about litigation. The board member thinks that the town is going heavy on the other litigant. So they go through their executive session, and then after that meeting comes out, the board member blabs what the town's litigation strategy is because they're talked off at the town. Problem. Now, on point, we had a case involving a clerk in one of our district courts. Now, court clerks, it dealt with query information, criminal offender record information. A lot of times, to get a public job, you've got to pass a query background check. Well, this clerk had a relative who was running for an election locally. And clerks don't have access to query information. But one day, this clerk went to her best friend in the court, Mr. Probation Officer. Those folks have access to query information. And she asked the probation officer to run a query check on her relative's opponent in that upcoming election without providing any context to the probation officer, who assumed it was a legitimate business request. So the probation officer runs the query check and comes up with a hit, an arrest record, which he then provides to the clerk, who then provides to a relative, who then released it to the media. And guess who won the election? Well, then we learned about it after the fact, and we will never take any actions to undo any democratic process, but we will take steps to enforce the conflict law. So the election stands. The commission investigates. The commission finds that that clerk violated the law in a significant way. In its decision, the Ethics Commission said, Madam Clerk, respectfully, even though you are not cleared to receive query information, once you did receive that under false pretenses, you were obligated to keep it confidential. Instead, you disseminated that information to somebody who was not authorized to receive it, and you did so to further a personal purpose. Get out your checkbook, this one's gonna hurt. Understand that this requirement survives your public employment. Doesn't matter whether you're a current or former public employee. The Ethics Commission, as a law enforcement agency, has a 6-year statute of limitations. 6 years within which we can take steps to enforce the statute. So somebody who's a public employee and learns of confidential information and then leaves their public agency or their term expires, and they then divulge confidential information that they learned while they were a public employee, if it's within that 6-year window, it becomes actionable if it is improperly disseminated to further a personal purpose. So political activity, we also have an advisory, because it does get nuanced. I mean, what I explained, it seems basic enough. No campaign of political activity on public dime in public buildings using public equipment and supplies. But it's not that cut and dry. Because elected officials, the law is more relaxed. Elected officials have more latitude to use their titles to get involved in political causes, to endorse candidates. If you are appointed, your title is a public resource. Appointed town employees, including board members, cannot use their official titles or town stationery in connection with campaign or political purposes. You can't endorse candidates. If you sign off on a letter with 20 residents endorsing so-and-so for some office, and beside your name is your town position, oops, we want to avoid that. So we have this advisory because it explains what can you do, what is prohibited. Examples on both sides. One of the other nuances involves political activity that might affect public agencies. Like, for example, if I'm on the school committee and the town is having a 2.5 override to build a new school, will the results of that political activity affect the school department? Yes. Now, am I prohibited from talking about the override because I'm a public employee? Well, that gets unworkable, because when you have those issues, resources marshal on both sides of the question, those in favor, those not. Yes?
Can you repeat what you said about an individual cannot endorse a public official if they can't, if they're representing a committee or board, but they
No,
can't?
a town employee, an appointed town employee, cannot use their title or town stationery to endorse a candidate. To do so would convey some sort of official town endorsement of candidacy, which is not allowed. Elected officials, however, have some wiggle room. Because they're office holders, not appointed employees, and they engage in political activity all the time to get the job and keep the job, they can use their titles 24/7. If I'm an appointed town employee and I'm running for some office, I have to use leave time from my town position to attend a campaign event. If I'm an elected official, I don't have office hours or requirements. I can hold a campaign fundraiser at any time of the day or night without restriction. So the law applies differently depending on whether you're appointed or elected to a public position. Now, getting back to agencies that are affected, and let me make this point and then I'll get to your question. If it is a 2.5 override to build a new school and I'm on the school committee, there is wiggle room under the conflict law that says the policymakers at an affected agency have limited ability to use public resources only for the purposes of informing the public discussion, but they cannot advocate, and only the policymakers. So the school committee members, the superintendent, maybe the business manager, they can use public resources to talk about what will happen budget-wise if the override passes or doesn't pass. But everyone else, or a rank and file school teacher, someone who's not a policymaker, they cannot use public resources to talk about the override. Go ahead.
Just so I'm clear, so say hypothetically I'm a member of the Conservation Commission. I'm not, but hypothetically
Sure.
I was. And there's a town election going on, and I endorse a candidate. Are you saying that on the person that's running, that I'm endorsing, they cannot say Joe Schmo Conservation Commission on their campaign literature?
Mm-hmm.
So that
Yep.
you cannot. So
No,
if
you
you're
can
an
say
appointed-
your name and your
Just your
give
name,
your
you
address.
cannot list
But it goes
your-
both ways.
Yep,
You're a town employee as a board member.
yep,
You cannot use your title to endorse that candidate, and they, if they are an incumbent,
yep,
see, because then they're a public employee, they can't put your name and title on any campaign literature. Now, what happens if somebody's not an incumbent? Well, they're not subject to the conflict law. That is sort of it's not a gray area, it's a loophole. You know, and we get complaints all the time
Can you
that
run that one more
non-incumbent
time?
candidates.
You just lost me there for a second, so I
Okay.
was following you. So just one more time, if you're an incumbent versus,
Okay, if you're an appointed public employee, you
Yep.
cannot use your title in connection with endorsing candidates.
right,
If you are the candidate and you are an incumbent,
yes,
means you are a public employee. The same rules apply in that you cannot produce any campaign literature which identifies public employees by title. You
right,
can do it by name, but not by title. Now, the loophole is, if I'm a candidate for office, but I'm not the incumbent,
yeah,
I'm not a public employee.
I got you.
Okay.
Okay, got it now.
Yeah,
Okay.
and sometimes people are
You
confused.
tied
by
the
that.
bow,
Mhm.
so, okay, so it's only the incumbents.
And it's good that you're confused, because then I go, see, we have this advisory which explains. Yes.
But could they use your name to endorse you without saying you're on the Conservation Committee?
Sure,
Just put your
absolutely.
name and
Yeah, I've been
list of
endorsed
people?
by, sure, absolutely. And if you're elected, they can use you saying, you know, selectman and school committee member has endorsed me. They can, because elected officials, as I said, there's a distinction between an office holder and an appointed employee. Okay. You'll be happy to know that not only does the conflict law apply to you when you're performing your public duties, but it can also apply to you when you're off the job. The conflict of interest law imposes a duty of loyalty on public employees to the town. And what that means is, in your off the public job capacity, you can't represent third-party interests before the town. You cannot be paid to work privately on matters that also involve the town. Why? Because it would compromise the duty of loyalty that the law imposes on you. So the language of the statute is a municipal employee is prohibited from acting as an agent or attorney for or being compensated from anyone other than the municipality in connection with any matter in which the municipality is a party or has a direct and substantial interest. Now, only a lawyer could have written that language. How does it apply? Well, that's what we want to talk about. Generally, if you're a full-time public employee, you can't mix your town business and your private business interests unless certain conditions apply. But for board members, where you are unpaid and you're not full-time or compensated or what have you, the conflict law has some wiggle room, recognizing that if the town says, hey, we need our citizens to volunteer to serve on the boards, but oh, by the way, if you have any other business interests with the town, you can't do both, who's going to volunteer to serve on a board? No one. So the law, the conflict law, contains a mechanism for towns to designate certain of its positions as special municipal employees. Now, we know you're all special, but this has a legal distinction. The town, through the Board of Selectmen, can designate certain positions as special municipal employee positions. Any position that's unpaid, or to the extent it's paid, it's for less than 800 hours in a year. So say you have an animal control officer that serves 1 day a week. You know, they're going to get paid, the total compensation is going to be for less than 800 hours. Or by the nature of the service provided to the town, it allows for private employment during normal business hours. Those positions are eligible to be classified by the Board of Selectmen as special municipal employee positions. It's not on a one-off or case-by-case basis. Like, for example, if a member of the Board of Health requests, hey, would you designate my position as a special, and the Board of Selectmen says yes, it's not one position. They have to designate Board of Health positions. All the positions have to be designated as specials. If you occupy a position that has been designated as a special, and hopefully you all have that, it enables you to continue to do business with the town, as long as it's not with the board that you serve on. With regular town employees who are not special, the restriction applies globally for the town, all departments, boards, agencies, what have you. For special municipal employees, the restriction about representing third-party interests before the town, being paid privately to work on a matter that also involves the town, it only applies to the board that you serve. But you can otherwise continue to carry out those business interests with all other town departments, agencies, boards, as long as your board is not going to be involved in the matter. Like if you are on conservation and you have a client, you do, say, wetlands flagging, and the client is going to be before the planning board, and Conservation Commission members have been designated as specials, you cannot represent the client or do the work even though the matter is going before the planning board, because that matter will eventually make its way to conservation. So you cannot do it if it involves your own board, or if your board is eventually going to be have some jurisdiction on that. Yes?
Typically in towns, would town council be an SME?
It depends. If the town council is contracted from a firm, so that they're not technically a town employee, they're a vendor, they provide legal services to the town, they can be designated as a special municipal employee. If they are an appointed town employee, town council position is a town position, and they meet the criteria, they're either unpaid, which doesn't happen, or they're paid for less than 800 hours, then they may be. In certain instances where it's just a small service. In other words, yes, they're town council, but they only provide services on an ad hoc, as needed basis, then they might qualify. But if it's town council as a town position, working half-time or full-time, they're not eligible to be designated as a special. They have to meet, the position has to meet the criteria of being unpaid, or if paid for less than 800 hours in a year, or the nature of the service provided to the town allows for private employment during normal business hours. And that's what town council, who is a lawyer in a firm, they work for the firm during normal business hours, so the position may be eligible to be designated as a special municipal employee position.
So it's less than 800 hours a year, so it doesn't make any difference if the person bills $800
an hour.
No, and you're getting down too far into specifics for me to talk about it.
Okay,
I would
all
just say, if the position qualifies as on the criteria I just used, it might qualify just because it allows for private employment during normal business hours. It meets that criteria, so the position can be designated. It gets tricky.
Okay.
For our purposes, all I can tell you is maybe yes, maybe no.
So it's one of those three.
Yeah, exactly. If it fits under one of those three criteria, then the position is eligible, but it must be an affirmative designation by the Board of Selectmen. They have to designate the position. And don't confuse representing third-party interests with representing yourself. You don't lose any of your rights because you're a board member. You are always allowed to represent yourself before any town board, including your own. You just have to be careful that you're representing yourself and not some third-party interest. In other words, if I'm on the planning board and Walmart wants to put in that big box store and the planning board's holding its public hearing and I abstain, and I sit in the audience, and at public hearing time I get up and say, I'm a resident of Main Street and I'm opposed and I'm here to speak for myself and all of my neighbors. Oops. You're okay as long as you say, I'm here speaking for myself. But once you invoke other people that you're speaking on behalf of, that crosses the line. You are not allowed to represent third-party interests before the town, because the conflict law seeks to restrict town employees from using their positions, their knowledge, their expertise, and benefiting third-party interests. You're there to be loyal to the town. Oh, I was going to skip this. The bottom bullet point. Contractors and consultants cannot compensate a town employee to work on a matter where the conflict law restricts the town employee. You're on the planning board. Well, let me give you an actual that we dealt with. I'm on the Conservation Commission. An applicant comes before Conservation with a notice of intent, which we then review and approve, and we issue an order of conditions. After the order of conditions goes out, the contractor hires me, because I'm an excavator and my private work, hires me as a Conservation Commission member to do the excavation pursuant to that order of conditions. I would violate the conflict law because I'm being compensated by a private party to work on a matter in which the town has an interest because they permitted it. The contractor who hired me to do that work, where the conflict law prohibited me from doing it, the contractor also violated the conflict law. And we had, in my example, we sanctioned both the Conservation Commission member and the contractor for violating the conflict law. So there is an exemption that we have to permit town employees who are parents. What if you're a town employee, but you have children in the school district, and there's a matter that needs attending to, and you need to represent your child's interest before the school department? Well, it would implicate the duty of loyalty restriction, except, common sense. Parents should be allowed to represent their children's interests before town boards, and so the conflict law allows that. If it's because we had a situation involving a school superintendent and a school committee member. The school committee member had a child in the district receiving special education services. Now those matters are normally handled by the special education department. But the special education department wasn't playing ball. So the school committee member went to his direct subordinate, the superintendent, and said, they're not playing ball. Would you like to play ball? The superintendent said, yeah, probably. So it resulted in an out-of-district placement in a private, expensive prep school, where the special education department said, that child does not require those services. That is unnecessary. It's an unnecessary expense for the town. So we went at that and we said, while the superintendent, while the school committee member can advocate for their children in a matter before the school department, because as a school committee member, you're in a supervisory position over the person you're going to advocate on behalf of your child, you need to file a disclosure. There has to be a public record that you're interacting with your subordinates where the law allows you to represent your child's interests. And then there's a provision in the law that says, what happens if the town forms a committee and we're looking to study a particular industry? Let's say one of the coastal towns is forming a shellfish advisory committee. And in the bylaw that was approved at town meeting, they say to staff the members of the committee, it's going to be 7 members, 3 of whom must be shellfishermen. They must be have industry expertise in this matter. Well, what happens if the Shellfish Advisory Committee is deciding matters that are going to affect the financial interests of shellfishermen? Well, their financial interests are going to be affected as well. There's a regulation that says in boards that require a specific expertise, an industry affiliation, those folks are going to be allowed to serve and to participate even if the matters will affect their financial interests, as long as it's a general policy issue. They can't handle matters that affect their financial interests uniquely or distinctly, but general policy that affects them, but everybody else who's similarly situated in the industry is going to be allowed. The second provision that applies to us after hours deals with contracts. And this is what the law says. A municipal employee is prohibited from having a financial interest in a municipal contract. Now, what the conflict law is designed to do is restrict what we call inside track situations. Situations where public employees who have control over jobs or contracts use their positions to obtain additional public compensation. That stuff has to be made available to everyone on an open and fair basis. So the conflict law says a municipal employee is prohibited from having a financial interest in a municipal contract. It covers inside track situations, but it covers a heck of a lot of other situations not designed to be restricted by the conflict law. This is the most confusing section because it's so broadly written, and until it's changed, we have to wrestle with it. But we have regulations and carve-outs that deal with situations. So we get a call from a public employee that says, I'm a town employee in this capacity. Can I take on a second paid town job if there's no overlap between position 1 and position 2? Or I work for this town department. Can I work on this vendor contract if it's with another town department where there's no overlap between my town position and the vendor contract? When we get those questions, the answer is no, unless you qualify under an exemption. Whether you qualify depends on an analysis of all of the relevant circumstances. And we tell people, don't assume the answer is no, because it may be yes. For example, even though the law says if you have a paid position with the town, you can't take on a second paid position, it doesn't apply to elected positions. A person can hold any number of elected positions, even if they're all paid. I can serve on the school committee and I can serve on the board of selectmen without violating the conflict of interest law. Because an elected position doesn't have the same contract connection that an appointed position does. As an appointed employee, you have a contract with the municipality to provide the services. It doesn't matter whether you're paid or not. It's that you've been duly appointed to provide these services. Whereas if you're elected, you're just an office holder. You don't have to do anything other than you have a title. Hopefully you're going to do something that the law doesn't require. And we get that all the time. Somebody was elected to the Board of Selectmen and they just won't show up. They won't participate. Can't we get rid of it? Not unless the town has a recall provision in its bylaws. You're stuck with it. You elected them, you live with them. If you are a special municipal employee, the law provides some flexibility. You can, if you are a special municipal employee in position 1, you can take on a second paid position, even if that position has not been designated as a special. The law only requires you to file a disclosure with the town clerk's office that you're holding 2 positions. Also, what happens if you hold a paid town position and the Board of Selectmen want to appoint you to an advisory board that's unpaid? Well, what's the problem? What's the financial interest in another municipal contract if I'm appointed to an unpaid position? I'm paid here, but I'm not paid there. So I'm not a municipal employee who has a financial interest in another municipal contract. But guess what? Once you wear that unpaid position hat, you're a municipal employee as well. And you're now a municipal employee who has a financial interest in that paid position. Implicates the conflict law. Confusing? Heck yeah. But by regulation, the commission says any town employee can be appointed to an unpaid position as long as they file a disclosure with their appointing authority in their paid position that they also hold that unpaid position. So it just sort of gives you a feel that while the restriction is what it is, there are workarounds. And so we want you, if a situation comes up, don't assume the answer is no, and don't assume that your neighbor's violating the conflict law. They may not be. There's a provision that says any town employee can serve on the Board of Selectmen. In other words, I can be a full-time firefighter in the town and also serve on the Board of Selectmen. Now, I would be a municipal employee, and presuming that the selectmen receive a stipend, a municipal employee who has a financial interest in another municipal contract. Implicates the conflict law, but there's a specific carve-out we call the Selectmen's Exemption that says that any town employee can also serve on the Board of Selectmen, but they must observe 3 conditions. Condition 1, to deal with the inside track situation, they can only take 1 salary. So do I want to continue to receive my firefighter's salary with overtime and benefits? Or would I rather take that measly stipend? But I have to choose. I can only be paid through 1 source. Second condition is, when I'm serving as a member of the Board of Selectmen, I have to stay out of matters within the purview of my department, the fire department. Third condition, I'm not eligible to be appointed to any other position while I serve on that Board of Selectmen and for 6 months after I leave the Board of Selectmen. So if I'm a firefighter serving on the Board of Selectmen, and I'm a regular firefighter and there's a promotional opportunity for fire lieutenant or fire captain, and I might be the odds-on favorite. I might have scored the highest on the civil service. I might be the best loved firefighter in the town, and the selectmen are just itching to appoint me or promote me. Nope, cannot. We had a police officer, he was a command rank officer, a lieutenant, and also serving on the Board of Selectmen, and while he was serving on the Board of Selectmen, the town wanted to expand the police department staff by creating a deputy chief position. He was the senior command officer, odds-on favorite to get any kind of promotion, beloved by the town, and so the Board of Selectmen appointed him to the position until we learned about it. And they said, guess what position you're giving up? And you're paying a fine because you didn't call us first, and it's an obvious violation with no workaround under the conflict law. When there are numerous exemptions, and what we try to do is if we learn that a public employee is not complying with the law, we try to get them into compliance. But if we can't and we think it's an egregious violation, well then the commission can take enforcement action. In this case, that person was sanctioned for violating the conflict law and had to give up that deputy chief position. But the town didn't like what we did, and the town wanted him to be the deputy chief, so they didn't fill the deputy chief position after he resigned from it. They held it open for 6 months. Once he was sanctioned and gave up the deputy chief position, he also resigned from the Board of Selectmen. And when he was off the board for 6 months, then he could be legally appointed to that deputy chief position, whereas the prior appointment was illegal. There are rules in place to protect the public interest. In some instances where there may be some overlap between position 1 and position 2, or position 1 and the vendor contract, the conflict law says if you're a special, you can still take on the second position or the interest in the vendor contract, but not only will you have to file a disclosure, the Board of Selectmen may have to waive the statute. They may have to look at that situation and say, yes, it's in the best interest of the town to let you do that, even though there's some overlap between the two, and then that would be allowed under the conflict. Okay, restrictions on appointments. If you serve on a board, say you serve on the Board of Health, and the board hires and supervises the health agent, and the health agent leaves the position, and you want to apply for the position, you can. But you cannot be appointed. You cannot be a Board of Health member and be appointed to the health agent, a position supervised by the board you serve on. You must be off that board for 30 days, and then you can be appointed. You can apply while you're a Board of Health member, and your fellow board members can consider applications, but you can't be appointed until you resign from the board and you're off the board for 30 days. And then if you were serving under the Selectmen's Exemption, I've just explained, there's a 6-month period that you have to be, if you are a town employee who also serves on the Board of Selectmen, there's a 6-month window. If you just serve on the Board of Selectmen and you want to leave the board to apply for a paid position, there's no 6-month window. But if it's a town administrator position that is appointed and supervised by the Board of Selectmen, and the town administrator leaves, you have to resign from the board, and the Board of Selectmen cannot appoint you until you have been off the board for 30 days. And then there's also a provision for housing authority employees. If you are a housing authority employee and you serve as an elected official, you can't be appointed to any other position in the town for 6 months after you leave the elected position. Okay, the final section of the law we're going to talk about deals with revolving door restrictions. So you serve the town, you leave town service, you're now a former town employee, and you now want to represent a client or a new employer before the town board or department that you previously served on. The conflict of interest law has what we call revolving door restrictions. The revolving door, public employees who leave their public positions today, and tomorrow they go through the revolving door, but now they're representing clients or other third-party interests before the department they just left. Can you do it? The answer to that exciting question, it depends. The conflict law has two basic restrictions. It looks at what did you do and what didn't you do, but was nonetheless under your official authority. In other words, if you're a department head for a town department, everything that comes into your department is a matter under your official responsibility. But you don't necessarily handle everything that comes in. You have staff to deal with stuff, you deal with stuff. You can distinguish between matters that you handled versus matters that, while you did not handle them, they were nonetheless under your official responsibility. So then you leave your town service and you want to go through the revolving door, only now you want to represent private parties before the board or department you just left. The law says, what is the reason for that representation? And if the reason for representing the client before the board you just left is in connection with a matter that you participated in as a board member, no. Permanent restriction. If you touched it on the town side, you can never then represent a third-party interest before the town in connection with those matters. And then, if it's a matter that you didn't work on, but it was nonetheless under your official responsibility, the law imposes a 1-year cooling off period. Why? Because as to matters that are under your official responsibility, when you leave town service, you still know stuff. You still know people. You still have influences. And the law says you don't get to use that stuff to benefit third-party interests. So if you touched it, you can never represent the client. But if you didn't touch it, but it was within your bailiwick while you were a town employee, you got to wait 1 year. So that you can't improperly use anything to benefit a third-party interest. If neither condition applies, it's open season. You can leave the town position today, go through the revolving door and represent some third-party interest before your former department, board, or agency tomorrow, as long as the reason for that representation is not in connection with a matter that you handled or a matter that was under your official responsibility while you were a town employee. Okay. Jim, did I miss something? I'm about ready to wrap.
One more question for you.
Sure.
If you had somebody in a position, say a selectman or a school committee person, or advisor, something like that, that makes a recommendation on the budget at a high level, and they have a member of an immediate family, spouse, that kind of a deal, who is a town employee, so they're making a recommendation on a budget related to them. What's the best way, from your recommendation, to handle that when they take a vote on that matter? How should they disclose that to the public?
Well, I don't give out advice. That's what our legal division does. But we'll tell you, generally speaking, voting on budgets is an issue. It can be a nepotism issue.
Okay.
We tell town employees that if you have family members working in the department and you're going to be approving budgets, if it's the budget, a general budget, one number, no, you've got to stay out of it. But if the budget is line item, and you're able to abstain from the salaries portion, you can otherwise vote on the budget, as long as you can abstain from the portions that will affect the financial interests of your family members. And we get that question all the time, especially in towns where people serve on boards and they have family members who are employed by the town. School department, police, fire, you name it. You are required to complete conflict of interest law education requirements. So you took the online training program. The town also distributed to you the summary of the conflict law they asked you to sign for. Those are statutorily required. Everyone from the governor on down has to do that. I can show you the governor's online training program completion certificate. But everyone has to complete those requirements at prescribed intervals. The summary of the law is an annual requirement. The online training program is a biannual requirement. And apologies if people had difficulty with the online training program. We are not blessed with unlimited budgets or technical resources at the Ethics Commission. It's using dated technologies, and people sometimes have difficulties, but that's what I'm there for. I get calls from hundreds of public employees every year about how to access the programs, what is required, and so forth. Don't be afraid to call if anyone has any difficulties. If you find that you have a conflict and you need to find out what the conflict law requires, you call our office, you ask to speak to the AOD. You will not talk to the AOD upon that phone call because we get over 6,000 calls in a year. You will have our receptionist taking information from you about who you are and the nature of your question to tee it up for the AOD, so they'll have some basis for talking to you in a useful manner. But they will call back usually that day or the next day. We try to return calls within 24 hours. We have a couple of ground rules. Because we are required to keep matters confidential, we don't give out third-party advice. We will talk to you about your situation. We will not talk to you about somebody else's situation. So sometimes we get calls where people ask, how would the conflict law apply to somebody else if they did? And it's, no, we don't provide third party. We also don't provide past conduct advice. It's all about getting out in front. Our legal division is authorized to give advice prospectively. You have an issue that comes up, some business opportunity or what have you, where they might be doing business with the town, and you need to know what does the conflict law require. You don't violate the law and then try to get a legal opinion that says you didn't. That ain't gonna happen. But you want to call us in advance. Don't do anything until you understand what your legal obligations are. So we don't give out any past conduct. And occasionally our legal division will get a call and they'll say, we can't help you. This is conduct that's already happened. We can't talk to you about it. But our enforcement division will be very happy. They're right over there. But understand, we don't want to inhibit anyone from calling us. We want to be there. We're the resource. We're the experts, and we want you to use us. Even if our legal division learns of a prospective violation, they will not report it to our enforcement division. When it comes to due process issues, there is a hard and fast wall that drops between those two operating divisions. They'll say, you may want to self-report this because getting out in front is sometimes the best course of action. But we can't give you any advice on everything that's happened up to this point. But going forward, this is how the law would apply 1.99. We want to help people understand how to comply with the conflict law whenever we can. Okay. The final slide is the most important. When in doubt, panic. When a situation comes up, just understanding when the red flag goes up, gift restriction rules, nepotism rules, code of conduct rules, duty of loyalty requirements, restrictions on acquiring a financial interest in another contract, and the revolving door. When the red flag goes up, call our office, call counsel, and we want to make sure that to the extent you want to comply with the conflict law, and we sincerely hope that you do, that we're there to give you the information so that you can. Are there any other questions? Thank you for your kind attention.
Thank you.